Good evening, I'm Julie Williams. A historic bill to end forced arbitration in sexual assault cases is one signature away from becoming law. My co-anchor Brandon Morano has been following this story for us. Brandon.
Julie, Congress just passed the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. Now the bill is on President Biden's desk. Today I sat down with an employment law expert to break it down, what it means for you. So what is forced arbitration? Most of the time, it pertains to employers and employees. Think of it as privately settling something outside of court.
That actually is their purpose, is to prevent people from going to court. What this bill would do would be to say you can't make people use private arbitration. They would still have an option if they wanted to use it, but they can't be forced into the private arbitration.
SIU law professor and employment law expert Cheryl Anderson calls the bill titled the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act a win for any sexual assault victim, no matter their gender.
It gives an opportunity for the victims of sexual abuse and sexual harassment to basically have more strength and the ability to bring their claims.
But the law didn't always just extend to your workplace. Up until 2018, the rideshare company Uber had forced arbitration in its user agreement, meaning if you agreed to the terms and conditions and booked a ride through Uber before 2018, you gave up your right to settle a sexual assault harassment or sexual assault complaint in court. And more often than not, you'd have to sign a non-disclosure agreement, meaning you weren't even allowed to talk about it. Senate Majority Whip Dick Durbin, one of the bill's many backers, had this to say.
It's becoming increasingly clear that the forced arbitration clauses have enabled sexual abusers to escape scrutiny while their victims are compelled to stay silent. That is just plain wrong. Survivors deserve accountability, and that's exactly what this law will deliver.
Would there be a political reason to vote against this?
Well, there are some aspects of the business community that are not supportive of it because they like their private arbitration systems and they feel like they work effectively, and so there's always going to be a certain segment of people who are politically aligned with like the chambers of commerce and places like that that might be more inclined to want to preserve the arbitration system.
And on Thursday, Congressman Mike Bost, one of the 97 members to vote against the bill, released this statement, saying, quote, victims of sexual assault and harassment deserve to have justice under our legal system, whether it is through arbitration or through a public trial. In many instances, arbitration itself is not the issue, but rather the use of non-disclosure agreements that are used to silence victims. While well-intentioned, this bill does not address confidentiality agreements, and therefore, it does not solve the problem it intends to. The U.S. Equal Opportunity Commission says 50 to 75% of women have faced some form of unwanted sexual harassment at work.
And that's just from self-reporting, too. In the last few years, I think it's become a little bit easier to identify yourself as a person who's experienced sexual harassment, but the prevalence was, once people were able to start really talking about it, the prevalence of it just became, astounding.
A number Anderson and the bipartisan group of politicians hope this bill can lower, one case at a time. Now, Anderson also calls this bill monumental because it will bring other cases to light that weren't previously known about because of private arbitration or non-disclosure agreements, meaning that if someone was on the fence about filing a complaint or report, they will now know that they have strength in numbers. That could lead to more class action lawsuits against companies and executives with cases of continual harassment.